Sir Bernard, thank you very much for agreeing to share your thoughts and interview today. You are, I'm sure most of us would agree, the master of the Mareva, as it was called then. So just a little bit about yourself. Could you just tell us a little bit about yourself, what you're doing now, and also just your background?
I'm still an active lawyer, a very active lawyer actually. Most of my time is spent in arbitration. I do a bit of mediation. I'm a judge of the Singapore International Commercial Court, sitting on appeal only. I was a member of the Court of Appeal of the Cayman Islands up to a few years ago. I'm time expired there, but not in Singapore. I'm very grateful for that. And I'm also a professor of commercial law at Queen Mary's Centre for Commercial Law Studies, where I have a course called Transnational Commercial Problems. And I lecture around the place as well.
Excellent. Okay today if I call you Sir Bernard?
Yes, call me anything. Call me Bernard.
Well, thank you. Okay, let's take you back to 1975. I think it was June 75, possibly the 23rd of June in terms of that period. And unlike today, Marevas or freezers weren't part of the tapestry. Tell us how the case arose. Tell us how you got involved and some of the initial problems perhaps about that particular request to seek an injunction.
Well, as you know, Mareva was preceded by a case called Caragorgis, which Geoffrey Bryce and Michael Howard took to the commercial court judge, then Mr. Justice Donaldson. He refused it, but allowed them to go to the Court of Appeal, and the Court of Appeal allowed it. So that was the Fonse de Rigo of it all, relying on the statute as the jurisdictional basis. My recollection of my involvement was that I was sitting in chambers one day and the case came to me. I had not done it in the commercial court before Donaldson J. I was asked to do it on appeal. Donaldson didn't like the idea of the injunction. He had refused it. He had in the back of his mind that there was a case which said it couldn't be done, but he wasn't able to put his finger on it. But when it came round second time in Mareva, he had found it, Lister and Stubbs, Court of Appeal case of late 1880s, I think, which said it couldn't be done as a matter of practice. And he gave permission to go to the Court of Appeal just to give it air and a chance to get to the Court of Appeal. And that's when I was brought in. So I wasn't there before Donaldson J. I was brought in. It was all, as I recall, over a weekend. I think the case was heard on a Monday. And it was before Master of the Rolls, Lord Denning, and Eustace Roskell, LJ, member of my old chambers, and Lord Justice Ormerod, as I recall. And I suspect I was very lucky because they'd done it once. They were certainly minded to do it again. And I was just there to give such help as I could. And what I think I was able to show them was that the jurisdiction under the statute, which went back to earlier versions in the 19th century, was regarded as being very broad, in principle very, very broad, as long as you had a legal or equitable right. Well, if you're a ship owner claiming time charter hire, you obviously have a legal right. You've got a claim for a debt, so there's no problem in that. Of course, where your ship was involved in a voyage which you couldn't get out of, with cargo on board, bills of lading issued, and as Roskill pointed out, you had a lien for subfreights, which may be the property answer to it all, really, but I don't know. It was obviously a very strong case to protect the owner against what is essentially a single-purpose company, an SPV, which is the way shipping works, right? One-ship companies, and they are single-purpose vehicles. And it seems to me that in such a case, the argument for some protection against dissipation was very strong. So anyway, I was able to help them with a bit of background, which put Lister and Stubbs, how can I put it, in its place or context, and showed that whereas it might have been a matter of practice, it wasn't necessarily in accordance with principle, and there we are, we were away. Of course, it being ex parte, none of the problems which came to be thought of over the next 50 years, which perhaps you're going to go on to, arose, and I didn't really have to answer for it. And I think I was very lucky in how can I put it, bowling on a very favourable wicket.
Very good. Very, very good. Now, I want to talk, I mean, that is very interesting and very helpful. There's a bit of a debate as to why it was called the Mareva, and I'm actually proud it was a shipping case. Shipping cases that had created this development. Indeed, some might say the best law is if it comes from a shipping.
Well, the law, our commercial law comes from shipping, because our commercial law goes back to the days when Britain, as an island, maritime, trading, entrepreneurial nation, was trading around the world. And we're very fortunate in having a commercial law which was created in a world of merchants, not in a world of consumers. So many countries come to their contract law in the modern world of consumers, but that doesn't answer the problem of merchants.
No. Well, it was called the Mareva. I think perhaps my own theory is my theory. I mean, it was. We didn't know the name of the other vessel, and there were two in the other case, and maybe the Mareva had more of a sort of a mystique to it. But anyway, it came in as a Mareva. There's not the other theory. Mr. Justice Foxton's theory is that it was the Court of Appeal's decision in rationalising it and giving more reasoning and overcoming the supposed obstacle that you refer to, the old authority that said you couldn't do it. So therefore, it was greater ventilation. But it was known as the Mareva. Yeah. It went on.
No, it was my intervention, really. There we were. Sometimes it was referred to as a Karageorgis injunction. Sometimes it was referred to as a Mareva injunction. Right. And I was involved in one or two subsequent cases. And as I remember, particularly the Pertamina case, which was a very big case, in which there was a Mareva injunction, there was an injunction, all right? Can't remember what it was called, perhaps called one day one thing and one day the other thing. It was inter partes. We were in the Court of Appeal. There were a lot of very prestigious senior lawyers involved. I can remember Nicholas Phillips being involved, the future president of the Supreme Court. And I persuaded Nicholas to call it a Mareva injunction.
Really?
and
the name stuck.
And the name stuck.
Name stuck. Okay. Well, thank you for that and that explanation. And I'll ask you a question now, which I perhaps will come back to. But when you got it, did you have that sense when you get these freezers, great excitement in securing it? Was there a great sense of excitement in terms of you'd achieved, you'd got it? There's that moment of excitement. Do you remember that moment? Because even to this day, when we get freezing injunctions, there's a moment for a lawyer of excitement. You've got it. It may not actually end that way. Did you feel the excitement?
I had absolutely no idea of the future. No, I don't think I visualized it at all. I had only I was called to the bar in November 1970. I became a tenant of what was then called 3 Essex Court. A year later, at the end of 1971, this happened within 4 years of that. In those days, a young tenant in commercial chambers didn't get into court all that much, certainly not by himself. I'm not sure there were herselves at that time, but I remember, my recollection is that it was the very first time I was in the Court of Appeal. And really amongst the first times when I was in court by myself. Can't quite remember when I first did a case in the commercial court. But it probably wasn't very long before that. I remember, well, it is my memory, I prefer to say, that it was my first time in the commercial court. And my memory also is that when the court had given its judgment in our favour and the appeal had succeeded, and I turned around, having received the judgments, to greet my instructing solicitor from Holman's, whose name I don't recall, and my recollection is he said something like, "Gosh, that went very well, but I suppose you're doing this in the Court of Appeal all the time." And the thought went through my mind, shall I tell him that I've never been in the Court of Appeal before? And I bit my tongue and I didn't say that. But that's my memory. Now, it may be a false memory in that it was another case, but I don't think it was, because it was so rare to go into court.
It was so rare to go into court. And did you then, once you'd secured that, did you get a stream of Marevas thereafter, so much so that you were sick to death of them? Or did it actually not, did it change your work in the sense that everyone thought you were the go-to person to get these Marevas? Or actually was it a more gradual development for you?
No, I thought actually, I think I knew that we had, we were on cutting edge stuff. You know, this was a new development. I mean, that's what Donaldson had said. Yes. This, and the Court of Appeal had changed the practice. So I knew we were onto a new thing, and I did think, oh well, this will be a fillip to my practice, because everyone will want to instruct me to get them an injunction. But it didn't happen that way. I mean, the odd case, but not a flood. And then Pertamina came along, and I was involved in that. But as I recall, not from the very beginning, not for the purposes of getting the Mareva, and that was big litigation involving a great number of ships and Malaysian oil and all that sort of thing. And then there was Siskina, where we sought to get jurisdiction in England on the basis of a freezing order. Right. And that was a case close to my heart, actually, because that was a case that started with me and ended in the House of Lords, ultimately in failure. But it was a very exciting progress there. And as I recall, we succeeded in the Court of Appeal in front of Lord Denning, the Master of the Rolls, in getting jurisdiction on the basis of a Mareva injunction in Siskina. So those are the cases that I remember. But it wasn't a flood. It wasn't a flood of cases. It wasn't the making of my practice. And all those great developments that took place, deciding what the test was, what the form of order should be, what protections you should give to the defendant, and so on and so forth. They were, on the whole, created in other cases. That's not cases that I was involved in.
Well, let's turn to those. And I found, in looking over the article, the lecture written by Mr. Justice Foxton, and also something you wrote a forward for one of your colleagues in Chambers, Mareva at 50, and written by Andrew Ayres and KC and Andrew Barnes-Graham, also extremely interesting in terms of plotting its course. And let's plot its course. Let's start life then with the Mareva. We're talking about an English bank account. We're talking about a claim that's within the jurisdiction. As you say, all the fetters and all the protections not really there. And then, of course, taking a look at today, we see that you can get freezers in support of foreign arbitration. You can get worldwide freezers where there's not an English bank account in sight, where there's a great discussion around the meaning of asset. Indeed, you've been involved judicially discussing that. How far do you take the concept of asset? And also disclosure orders. Personally, I find disclosure orders, they're referred to as the teeth of the freezer or the teeth of the Mareva, hugely important. And they guide you in terms of what next. So the Mareva has grown over those 50 years. It certainly hasn't stood still. Do you have any comments on that? Again, you say you didn't at the time think perhaps that it would become such an important development. But do you have, you were obviously involved in some of those stages of growth, but did you ever think at stages, gosh, look at this, look what the law, textbooks are written about it, Stephen G's textbook.
Yes, which is probably about 600 pages long or more.
It is.
David Foxton, in his excellent lecture, complains how expensive the textbook is because it's become such a big subject.
Sure. I also knew and I worked with Mark Hoyle with the other textbook, which was a smaller version, a cheaper version in terms of cost. And that, I think, ultimately didn't go on, but Stephen G's, obviously, book is the one. So did you, and looking now, did you think at any stage, gosh, this is really becoming something, a worldwide freezing order that has little or no connection with this jurisdiction?
Well, I was certainly conscious of its growth, even if I wasn't involved all that much in arguing some of the big issues along the way. But you're quite right. It's extended around the world, not in every place. And my understanding is that America, which did experiment, I think, perhaps even before 1975, in something along these lines, decided that it was too powerful a weapon and unfair. And I think it pulled back from that. And I haven't really kept abreast of American law. Nevertheless, in other common law places, it's gone around the world, where it may be called a Mareva or freezing injunction, whatever it is. And in, I think, most of the common law world outside America, it's to be found. And it's extended into a worldwide, as you say, a worldwide injunction. It's extended against non-parties. It has extended in protection of litigation outside Britain. So you can get an injunction in Britain in support of litigation outside Britain. It has become enshrined in statute and in our civil procedure rules. And along the way, so many issues as to what the test is and what the assets covered by it are, and what are the right protections and so on and so forth, have had to be decided. I remember thinking in 1975 that the critical question was dissipation. And I remember thinking in my mind, this is my memory, that the idea of dissipation was, as it were, a culpable one. And of course, nowadays it is true that the freezing order in its most useful form is used against defendants who are culpable, who are very culpable. They're not only concerned in dissipating their assets in the face of a possible judgment, and who doesn't want to do that, but they are people who are fraudsters and who have stolen vast sums of money and have hidden it all over the world. And the Mareva, with its disclosure order, is a very, very, very powerful weapon. Yes. And then following on the disclosure order is the contempt of court application. So you have your freezing order, then you get your disclosure order, yes. Teeth, yes. And then you have your contempt of court application, yes. Which is the mouth snapping shut, yes. With the teeth closed. So that's the way it's gone. But I remember thinking dissipation, that was a very culpable thing. But whatever the original court in Mareva had in mind in talking about dissipation, the truth of the matter is that it's not necessarily a culpable thing. It might be. It's extremely useful where you've got a defendant who is culpable in the past and certainly would be in the future. But the idea is, I think, that in a situation where you have a defendant who there are good grounds for thinking will want to make itself judgment proof, pending a judgment. Yes. That is the dissipation you have in mind, which is why once you come to set out the order in words, it of course allows you to use your assets for ordinary business, yes. Purposes, yes. And of course to allow you substance to live your life. Generally it's a business life, and to pay your lawyers, and that's a very, very important part of the fairness of it. But dissipation, of course, you don't need a freezing order against BP. But where you're dealing with single-purpose vehicles or one-ship companies, which is where it all starts from, there it is so easy just to transfer the money into another pocket, yes. Of the owner. And that is really what the dissipation is about.
I've always thought dishonesty is helpful. It's not all the way, but it's not essential either, because dissipation is the objective test.
But I don't think I realised that then, but that's as it has come to be.
I always think, even to this day, when you see a penal notice, the way it's expressed, and that comes off a fax machine or nowadays through email, it doesn't mince its words, does it? And certainly we find it very effective to this day. Two areas, actually, apart from just getting a freezer or Mareva when you are concerned about dissipation, maybe pre-arbitration or pre-court proceedings, post when you have an award or judgment, post-freezers are also increasingly popular. And because you haven't paid the award,
Why not? You haven't enforced it yet.
fairly good example of not actually.
I think Miss Justice Foxton says you don't have it in your final order, but if I were counsel, I'd always want it in my final order.
Yes, no, we do find that again an encouragement to honour awards and judgments. Let's talk about the balance. You mentioned the balance, the balance in terms of how the law's evolved, ensuring that somebody that's a target of a freezer can, very importantly, spend on lawyers, but also live. But as fraudsters also get more sophisticated with structures, the concept of asset has to perhaps expand, or the prospect of being able to stretch a freezer further perhaps than originally intended. Any comments on that? It should keep pace, unfortunately, with the creativity of fraudsters. Do you agree with that?
I do, particularly with fraudsters, and particularly with the very, very sophisticated means by which they hide their interests in the hands of friends and so forth. So one talks nowadays, doesn't one, about the ultimate beneficial owner. But the ultimate beneficial owner is not really a legal construct. It's a pragmatic construct. And since I've used the word pragmatic, I think that at my time of life, I have come to ponder more and more about the contrast between principle and pragmatism in the law, and even to look at jurisprudence, let alone protective orders like the freezing order, in terms of legal pragmatism as well as legal principle, and to ask myself the question where principle begins or ends, or pragmatism begins and ends. And I've rather come to the conclusion that they somewhat merge into one another. And I think looking at the freezing order from that point of view, I see it as an essentially pragmatic judicial tool to protect the whole principle of justice. I mean, the whole principle of justice is that you can go to a court and put your claim of right before the court. And we all know it takes a long time to get a judgment, if you're ever going to get a judgment in your favour. And over that period, defendants, even the most honest of defendants, who have not used any deceit at all in their dealings with you, are, of course, anxious to avoid the judgment, and may do so. I mean, there are laws, aren't there, which means that as you see your company going down the drain, you mustn't do certain things with the assets of your company, and the law is there to protect. But there isn't a law that says that as a defendant you can't use your assets as you wish until the freezing order comes along, right? So it is a sort of judge-made law. I can't call it statute, it's judge-made law to protect the whole idea of judgment. Yes. And it starts off when you're just talking about cases within your own jurisdiction. You could say that you're protecting the jurisdiction of the court. Yes. What's the point of the court going to judgment if assets have been removed in the meantime? Once you do it in protection of other courts, it is one court helping another court out of a matter of judicial comity, you might say. But I see the whole thing as a pragmatic, judge-made, based on the statute, of course, that's the foundation of it, yes. judge made pragmatic attempt to make access to the courts worthwhile, instead of a meaningless charade.
Make justice matter. Almost so. On reflection, it's a merger of principle and pragmatism that fuels the Mareva freezer. That merger of principle but pragmatism as well to make justice matter.
Yes, and so you raised the question of definition of assets. You see, well, once you realise that assets may be hidden in all kinds of ways, and hidden in the apparently legal and beneficial control of someone entirely else,
Or otherwise.
but you really control it, but the defendant really controls it, you need to have a pragmatic answer to that. Now, it doesn't quite work with principle, which is embedded in the idea of a legal or beneficial interest. But there you are. You've got to be alive to all the deceits of the fraudster.
Absolutely. I was reading that and you sure heard this, that the Mareva or freezer was referred to as one of 2 nuclear weapons. I don't actually know what the other one was.
I think it's the Anton pillar, isn't
Really?
it?
Okay.
I think it's the Anton pillar,
I see.
which came along not long after, like the Mareva. It was given a name, and it took its name from the case in which it was first granted. And I think that was the other nuclear one.
Right. And your assessment of it, do you think it's still nuclear, or have we all got used to it? And do you think it's in good health for the next 50 years?
Now, I think, but I stand to be corrected, that nuclear comes from Mr. Justice Donaldson.
That's right.
Is that right? Yes.
That's right, yes.
So it rather reflects his deep-seated view that this shouldn't be done at all. So he calls it a nuclear option. And it is a very powerful weapon, and it is true that I think that it needs to be controlled, and you always have to have a view that it operates fairly between the parties, because you don't have a judgment debtor yet. And the test, which I think in the most recent case of Lord Justice Popplewell, says that it's a serious issue to be tried test, and not a good arguable case test. So it's not necessarily the strongest of tests. So there you are. It's just an interim injunction. You haven't got to the end of the day. You don't quite know where the merits are. You have to protect the defendant, and I think that's rather important, particularly in the absence of any suggestion of fraud or culpability. I rather regard it, since we're talking about metaphors like nuclear option, I regard it as an iron dome. It isn't the threat of nuclear Armageddon before which everyone has to surrender. It is an iron dome against people who don't want to meet their responsibilities in law.
So you go for construction, not destruction.
If you like, or protection, not aggression.
Indeed.
Although you start with an application, it's a defensive application. Yes. It is a counter move to an anticipated dissipation. All right. Yes. So I look upon it as an iron dome.
Iron dome to protect. Well, I think it fits certainly with my experience, and how actually it can be so significant to the parties, as you say, to preserve the ring, to protect. Actually, at the end of the day, justice. Otherwise, that can also dissipate